One Ontario lawyer is utilizing a unique angle to defend freedom of expression as it relates to medical professionals' abilities to share contrarian opinions online, despite their regulators' demands. Tamara Ugolini here with Rebel News, and today's report features the second part of a two-part series about the case of Ontario physician Dr. Mark Trozzi, whose COVID-19 communications online have been deemed by his regulator, the College of Physicians and Surgeons of Ontario, as professional misconduct. On October 6, 2023, the tribunal found him guilty of professional misconduct for making unprofessional statements about vaccinations, treatments, and public health measures for COVID-19. This included an issuance of medical exemptions for the COVID-19 vaccines and a finding of incompetence. As a result, the college has revoked his license to practice medicine in the province of Ontario, has ordered Trozzi to present in front of a panel to be formally reprimanded, and has ordered him to pay college costs totaling $94,960 by February 23rd, 2024, a date which has since surpassed. If you would like to see the first part of this interview, you can do so at nomoreshots.ca or by referencing back to a hyperlink in the written copy of this video report. Now, in this second part, I interview Dr. Trozzi's lawyer, Michael Alexander, from Litigation Works and Justice for Medicine. He joins me to discuss the process that led them to this October 6th determination. Have a look.
Well, we've been fighting this through a number of hearings. We've had 2 motion hearings at the college, which that's unprecedented. They haven't had motion hearings there before, where we challenged the college on its investigation orders, because you have to write an order to go after somebody, and it has to be in accordance with the criminal standard, which is reasonable and probable grounds. And quite clearly, in all these investigation orders, they failed to meet the criminal standard of reasonable and probable grounds. So you have to state what the offense is, and then you must produce evidence in the order that makes it credible that an individual has actually, in all probability, committed an offense. Well, not only did they not define the offense, they don't mention any evidence. So there's no way this meets the criminal standard. Well, we lost on that, but we will deal with that on appeal as we now go into the court system. But then we had a discipline hearing and a penalty hearing. So the discipline hearing, we weren't really allowed to raise this issue of the status of the investigation orders because that ship had sort of sailed. Though we, as I say, we can raise it on appeal. So really at the discipline hearing, a lot of it came down to the standard of practice, which was never defined beforehand and which was never fully defined in the course of the hearing. And so what the college does is they take you down the road to a hearing, and then at the last moment, they decide what they're going to charge you with, and then they bring on evidence that you've had no notice of the charges beforehand, which itself is a legal problem and is appealable. So we went to the discipline hearing. They found that Mark was incompetent, that he had not met the standard of practice, though they didn't fully define what the standard of practice was. They presented an expert witness, Dr. Michael Gardner from the University of Toronto. He admitted that he never refuted Mark's 41-page expert report in which he defended himself at an early stage. So Mark's position on the science throughout this hearing remained unrefuted and unaddressed. And then they brought on another witness, Dr. Nomi MacDonald, who talked about the harms resulting from disinformation. Well, Mark was never charged with spreading disinformation, and none of the harms that she talked about were connected to anything that Mark said or did. So all of these issues, the evidence, reasonable and probable grounds, the standard of practice, all these things where they made egregious errors will now be appealed into the court system. And we'll go into the court system now on appeal based on a statute which gives us the right to appeal. And that means that we go into the system on the standard of correctness, where the court will require the college to get the right legal answers on all these issues around evidence, reasonable probable grounds, standard of practice, and so on.
And I suppose that was, in a way, the intent all along, was to get through the rigmarole being presented and mandated by the college to the real courts, for lack of a better word, who could apply those more robust tests.
Mm-hmm. Yes, we never expected to win at the college. It was just a question of how badly we were going to lose, because administrative systems that these colleges run in Ontario, there are 22 health colleges that are all under the same legislation. They are institutionally biased. I have yet to read a college decision where a doctor actually wins. We knew going ahead. So this is what we're facing. So what we did was we did a tremendous amount of research and we laid out the case law for an appeal when we finally got to the point we're at now. So we did a lot of hard work at the beginning to set ourselves up to make the best possible case when we go into the court system.
Alexander has since filed an appeal which has always hinged on freedom of expression and the fact that the guidelines and recommendations set forth by the CPSO were never laws or regulations. Alexander argues for the protected right of minority or dissenting opinions to be expressed and says that minority opinions are immune from the state's imposition of Section 1 of the Charter, which allows for the state to place supposedly reasonable limits on all of the other sections, if justified. In paragraph 58 of his factum, Alexander says, "The right of the government and the people to spread misinformation, as extreme as it may seem, has a rational foundation in a democracy where each person is the best judge of his or her own interest. Each person is necessarily the ultimate judge of what is true and what is false. Thus, the court's willingness to endorse the right to spread misinformation must be understood as a stand against state censorship of any kind. That is, armed with information, people can decide for themselves what is true and what is false. Based on this, Alexander further asserts that the core purpose of Section 2B of the Charter is to protect minority opinions because they are essential to the actualization of good government and the pursuit of truth in all matters, stating that it is well observed that the truth almost invariably begins as a minority opinion. He says that provocative remarks are sometimes needed to get the attention of others, citing a case from the Registered Nurses Association of Saskatchewan that found the most important reason freedom of expression cannot be unduly constrained is to avoid offending others, and that criticism will tend to upset the target of that criticism, and criticism, even blunt criticism, is essential to healthy debate. Alexander refutes expert testimony used in Trozzi's case to prove that his statements about the lack of safety and efficacy of the COVID-19 injections were correct by acknowledging that the college's own expert did not read Pfizer's 6-month clinical trial data. But proving this is going to be a long and drawn-out process, which Alexander says the CPSO depends on.
The college counts on this. They can charge $10,000 a day to a member to conduct a hearing. So you have the fact that this takes a long time, to get through their own legal process, and then you're into a much longer timeline if you decide to go into the court system. And on top of that, within their own process, they can charge you $10,000 a day for a hearing. So that's how Mark's cost got to just an absolutely unreasonable number. And so that discourages most doctors from fighting. So doctors tend to settle because the whole system has been set up to be so time-consuming and so costly. Nobody wants to go down that path.
Whether Dr. Trozzi wins or loses, this is a case of great public interest that will determine the state of the constitutional right to freedom of expression in Canada and define the extent of regulatory colleges' authority in it, especially as it pertains to medicine. I reached out to the CPSO with a media request to inquire about a few things discussed in this interview and the previous one with Dr. Trozzi, and this is how they responded. Firstly, I asked in regards to the modified RNA COVID-19 vaccines what steps the CPSO had taken to ensure physicians have access to the Health Canada acknowledged risks associated with the injections and to uphold informed consent. The CPSO responded that they shared guidance from the Government of Canada and the Ontario Ministry of Health regarding contraindications for the COVID-19 vaccines on their website. The link provided goes to a web page titled FAQs for Navigating a System Under Stress that was last updated June 29th, 2023. It's under the section titled Patients Are Asking Me to Write Notes Supporting a Medical Exemption from COVID-19 Vaccines. What do I need to know? There they say that there are very few acceptable medical exemptions to the COVID-19 vaccines, which are only available if you actually received your first vaccine and have a severe allergic reaction and or develop heart inflammation known as myocarditis or pericarditis. They uphold the notion that these exceptions are rare, and state vaccines have been proven to be both safe and effective. So written notes for patients who qualify for a medical exemption need to clearly specify the reason they cannot be vaccinated against COVID-19, which would include a documented, clear medical reason, including their medical information that supports the exemption, and the effective time period for the medical reason, i.e. is it permanent or time limited. The CPSO still supports physicians declining to write exemption notes requested by their patients without the above stipulations, and at this point, what doctor in their right mind would write a note given the extreme reprimand and medical license stripping faced by doctors doing so? But here's the kicker. The CPSO recommends that doctors not enable avoidance behavior and empower vaccine anxieties through an exemption. Responsible use of prescription medications and or referral to psychotherapy may be available options, they say. Next, I asked how the CPSO advocates on behalf of physicians throughout the pandemic, acknowledged by their own annual report as causing chaos and misery within the profession. They responded by stating that the CPSO regulates the practice of medicine. We provided clear information to physicians about appropriate practices during the pandemic on our website. We suggest contacting the Ontario Medical Association to discuss advocacy for physicians, so they just don't even do it. I also asked how many patients are without a family doctor or emergency care physician due to CPSO-induced COVID-19 related investigations by them, to which the CPSO does not collect this type of data. But some rough estimates based off of approximately a dozen doctors who have either retired early, left the province, or been stripped of their duties puts this number in the thousands. Fourthly, I inquired about allegations against the CPSO for criminal negligence and otherwise. How does the CPSO respond to allegations of that nature? They deflected completely and said that physicians hold a unique position of trust with the public and have a professional responsibility to not make comments or provide advice that encourages the public to act contrary to public health orders and recommendations. Physicians who put the public at risk may face an investigation by the CPSO and disciplinary action when warranted. Next, I asked what role the CPSO's medical misinformation policy played in physicians' unequivocal adherence to COVID-19 public health measures. The CPSO said that some of the guidance they shared during the pandemic was misrepresented by some on social media and in other forums. As stated in their social media policy, physicians are required to disseminate information that is verifiable and supported by available evidence and science if making statistical, scientific, or clinical claims. It is important, they say, for physicians to also consider the potential associated risks of sharing such information. Lastly, I asked what recourse is available to physicians when the CPSO gets something wrong, particularly the value of hindsight being what it is, and in light of new data, to which they responded, the CPSO welcomes evidence-informed feedback from our registrants about our policies and advisory documents. But hasn't all of this worked in the exact opposite way to limit or even eliminate the favorability of giving feedback? After all, would you want to give feedback if it meant that you may be punished and have your license stripped for going against the grain or offering a contrarian, critical perspective? For Rebel News, I'm Tamara Ugolini. COVID-19 dissidents have been sounding the alarm on the lack of sound data around the authorization of the novel injections for years. If you want to learn more about this topic or send a form email to Federal Health Minister Mark Holland, you can do so at nomoreshots.ca, and there you can also chip in to support our journalism if you're able to. All of that and more at nomoreshots.ca.